There is a hierarchy of mental states to consider when analyzing an individual's liability for a case involving the setting of a fire, going from the most criminal to less criminal to not criminal at all. The most serious charge is arson, which has to do with willfully and deliberately setting fire. Less serious would be reckless endangerment, such as throwing a lit cigarette out of the window into some brush on a dry day. To complete accident, which would not be criminal at all, such as the dog knocking over the barbecue, setting fire to the house. Ultimately, when prosecuting a case involving the setting of a fire, it's the state's burden to prove the mental state required to convict you of the crime.
Here in Nevada, first-degree arson involves the burning of a building, a home, or a mobile home, whether occupied or not, or the burning of personal property that's occupied by someone else. It's punishable as a Category B felony in Nevada with 2 to 15 years in prison or a fine of up to $15,000. Second-degree arson involves the burning of an empty, abandoned building or structure. It's punishable as a Category B felony as well, and a punishment of 1 to 10 years in prison.
Third-degree arson, on the other hand, here in Nevada, really arises in two possible situations. One is when you set fire to somebody's personal property. So it may be their books, their filing cabinet, their clothes. Not a structure, but personal effects. Also, third-degree arson can be charged when you set fire to timber or brush or vegetation or forestry. Now, third-degree arson is a Category D felony, which carries 1 to 4 years in Nevada State Prison. Keep in mind, however, that if you set fire to someone's personal effects or vegetation, and that fire should spread, let's say, and engulf homes, then third degree can escalate to first degree arson, which is much more serious.
Arson and insurance fraud are so closely related, even under the NRS statutes, the numbers are very close together, because it's very common that we see allegations of arson involving claims for insurance. So it could be that there's a property that's been vacant for a long period of time that's highly insured, or a vehicle that's insured that gets set on fire, and then an insurance claim is made. Often, it's the investigators for the insurance company that will tip off law enforcement that there was some type of foul play, giving rise to a criminal investigation for arson. Most of these cases arrive in situations where somebody is economically desperate, they've fallen on hard times, an otherwise law-abiding citizen finds themselves being prosecuted for something that in normal circumstances they never would have found themselves involved in. And I think law enforcement agencies are aware of that. It's not uncommon that when we negotiate these cases that we can achieve a reduction or outright dismissal upon payment of restitution in full.
Arson is one of those crimes where a lot of innocent people get wrongfully accused. The good news is that here at Las Vegas Defense Group, we have an excellent track record of fighting hard for our clients in arson cases and obtaining results that lead to the charges either being dismissed or reduced.
I've been involved with arson cases both as a prosecutor and as a defense attorney. And I can tell you from experience that county arson investigators often do a very quick and slipshod investigation. If anything looks suspicious, they're very quick to determine that it was an arson. And if somebody was in the vicinity, they're very quick to point the finger at that person as being the suspect or the person who set the fire. Arson investigators like you to think that the techniques that they use are very scientific, but the reality is that often it's pseudoscience and often junk science. And all too often, they come into an investigation and they've already decided who their suspect is. And they basically take the evidence and they shape it and they mold it to fit this preconceived conclusion that they've already drawn. That's why it's so important if you're charged with arson or your family member is charged with arson that you have attorneys who understand fire reconstruction, who understand arson investigation and can really go to court and challenge these arson investigators.
One common defense to a charge of arson would be accident, that you did not willfully and maliciously set the fire. It was merely an accident. For example, if you were cooking on a deep fryer in your kitchen and the oil combusted and set fire to your cabinets and ultimately the house burned down. In this situation where you didn't intentionally set the fire and you weren't acting in a reckless manner, the law would completely exonerate you from criminal liability for the crime of arson.
Another common defense is that you did not set the fire. Even if a fire investigator was pointing the finger at you, we're not going to accept that answer. In order to do a thorough investigation, we like to bring in an independent expert to do a complete fire reconstruction to establish as a defense that you did not set the fire.